Imagine going into work one day, logging on from home, and discovering that your employer has been silently watching everything on your personal computer. Not your work laptop, your personal computer, the one you own. The one with your bank statements, your medical records, your private messages, your late-night browsing that has absolutely nothing to do with your job. Every 5 minutes, a screenshot, quietly saved to a company server, for 7 months. Without your knowledge, without your consent, and without a single word in any document you ever signed. That is exactly what happened to one IT worker in Texas. And what he uncovered when he started digging is the kind of story that will make you want to go check every single program installed on your computer right now. Let's set the scene so you understand exactly what we're dealing with here and why the stakes here are enormous. When the pandemic hit and companies scrambled to shift their workforce to remote operations, a lot of employers made deals with their employees. Use your personal computer as a workstation. Install our software, connect through our VPN, and we'll keep business running. Millions of Americans agreed to this arrangement because they had to. They needed their jobs. And in the chaos of that transition, a lot of legal fine print got skipped, glossed over, or simply never written in the first place. This particular company based in Texas was one of those employers. They asked employees to install work software on personal home computers, connect through a company VPN, and work from home indefinitely. That part is not unusual. What is unusual, what crosses several very serious legal lines, is what the company quietly bundled into a routine software update 7 months before this story came to light. Hidden inside what appeared to be a standard update package was a program called ActiveTrack. For those who don't know, ActiveTrack is a legitimate employee monitoring software. Companies use it all the time. It can track websites visited, time spent on applications, and yes, it can take periodic screenshots of a user's screen. On a company-owned device, with proper disclosure and consent, tools like this are generally legal and commonly used. But this situation had none of those guardrails in place. The software was installed on personal computers. The employees were never told. Nothing in any signed document gave the company permission to do any of it. And the update was specifically designed as a one-click install that skipped the end-user license agreement entirely, so employees wouldn't even have the chance to read what they were agreeing to. That was by design. Now here is where the story gets deeply personal, because the person who uncovered all of this was not a privacy lawyer or a journalist. He was an IT worker at the company, someone who had elevated access to internal systems as part of his job. And what he found when he started looking around was far worse than he ever expected. It started when he noticed something strange about how the VPN was operating. He began to suspect that still images were being captured from employee screens when they were connected to the company network. He did what any curious IT professional would do. He started investigating. He reviewed the EULAs for every single work program employees were required to install. He went through all the signed employment documents. He combed through the company handbook. He was thorough, and he found nothing. Not one line of text that disclosed the screenshot monitoring, not one sentence asking for consent. Then he found ActiveTrack buried in that 7-month-old update package, and he found the repository where all those screenshots had been saved. What he saw in that repository stopped him cold. He pulled up folders at random and immediately realized that computers clearly not owned by the company, personal devices purchased by individual employees, were in there. Their screens had been captured, their personal activity had been recorded, and then he saw the timestamps. 3 in the morning, screenshots from employee computers at 3 in the morning, websites being visited in the middle of the night that had absolutely no business being stored on a company server, personal browsing, private moments, all of it captured, cataloged, and sitting in a folder that multiple managers had access to. He brought this to his boss. He laid it out clearly. The lack of consent, the personal devices, the off-hour surveillance. His boss's response was breathtaking in its casualness. The boss acknowledged they knew. He said the company had intended to update the employee handbook the previous year to include language about the monitoring, but had simply forgotten. They planned to add it in November and have everyone sign it then. As if the solution to secretly recording people's private computers for 7 months was just to update some paperwork later and move on. The IT worker pushed back. He pointed out that the images already stored were obtained without consent and should be deleted. The boss refused. Local managers were using those images to track productivity. They couldn't just get rid of them. And then came the directive that revealed just how aware the company was of its own exposure. The boss asked the IT worker to delete all screenshots taken before and after business hours, not because it was the right thing to do, but to limit the evidence of how invasive the surveillance had been. The after-hours screenshots were the most obviously indefensible, so those needed to disappear. But the ones taken during work hours, those were staying. Still no consent, still personal devices, still completely undisclosed, just slightly less embarrassing. The IT worker was then told to keep quiet about all of it. His access to the repository was framed as a privilege, implying that he should feel fortunate to know the truth rather than outraged by it. The company's plan was to quietly patch the software to stop capturing before and after work hours, update the handbook in November, and pretend none of this had happened. He wasn't satisfied with that answer, and honestly, neither should any of us be. So let's talk about what actually matters here legally, because this situation involves several distinct and serious areas of law. The first and most significant issue is the Computer Fraud and Abuse Act, which is a federal law. Installing software on someone's personal computer without their knowledge or authorization and using it to capture images of their screen is not a gray area. Personal computers are not company property. The employees did not consent to monitoring software being installed. Framing it inside an update package designed to skip the consent screen doesn't make it legal. It arguably makes it worse because it demonstrates intentional concealment. Texas also has its own wiretapping and electronic surveillance statutes that prohibit intercepting electronic communications without consent. Screenshots of private browsing activity, personal accounts, and off-hours computer use could absolutely fall under these protections, depending on how a court interprets the conduct. There is also potential exposure under privacy tort law. If employees can show they had a reasonable expectation of privacy on their personal devices and on their own computers outside of work hours, they absolutely did, then the company's conduct could constitute an invasion of privacy. For the IT worker specifically, his situation is complicated. He deleted files at his employer's request. If those files later become evidence in a lawsuit or regulatory action, deleting them, even under direct instruction, could be characterized as destruction of evidence. That is a serious issue. He did not initiate the surveillance, but he participated in the cleanup. That matters. If he is ever questioned about this, he needs his own legal counsel, separate from any attorney representing the company. His interests and the company's interests are not aligned. For the company, the exposure is significant. Class action potential is real here. Every employee whose personal device was monitored without consent is a potential plaintiff. The fact that managers were actively using the screenshots and that leadership knew the consent documentation was missing and chose to continue anyway could support claims of willful violation. Willful violations tend to carry higher damages. So what can you take away from this if you are working from home and using your personal device for work? First, audit what is installed on your personal computer right now. If your employer had you install software or connect through a VPN, look carefully at everything on that machine. You can check your installed programs list, your browser extensions, and your system processes. If you see something unfamiliar, search for it. Second, read every EULA before you install anything, even if it is sent by your employer. You have the right to ask questions before clicking install. Third, if you discover something like this at your company, do not delete anything yourself and do not follow instructions to cover it up. Document what you found. Write down dates, conversations, and what you observed. Then consult a private attorney, not your company's HR department, before you take any action. Fourth, understand that consent is not retroactive. A company cannot monitor you without permission and then fix it later by updating paperwork. The conduct that already occurred happened without consent. That legal exposure does not disappear because they add a line to the handbook in November. And finally, if you believe your employer has been capturing your personal computer screens without your knowledge, you may have real legal options. An employment attorney or a privacy attorney can review your specific situation and tell you whether you have a claim worth pursuing. If something like this has happened to you, or if you are currently in a situation where you suspect your employer is monitoring your personal device without consent, the most important thing you can do right now is stop, document everything, and get proper legal advice before you say or do anything else. This is exactly the kind of situation where the first move you make matters enormously. If you found this video helpful, consider subscribing so you never miss a breakdown when a real legal story this important hits the internet. These cases are more common than most people realize, and knowing your rights before something like this happens to you is the best protection you have.